All right, y'all. Hey, man, it's me, Joe Solly, again. Um, Back, man. It's Under the Color of Law, and I want to talk to y'all today, real quick, again about probable cause, and I want to get a little more in depth. I know I said I wasn't going to do it right away, but I'm just going to give a brief understanding of explanation of what it is. Last week we talked about due process and the 14th Amendment, and how if you break the 4th, you break the 14th. The Constitution complement each other, and the process that is due to you as an American citizen is the probable cause standard. And you go on to court, and the warrants and all that stuff. All that is a process that is due to you as a citizen. That is your right to get to know the identity of your accuser and all that stuff. That's the 5th. I will get to that in a second. However, the process back to the 4th and the 14th is it's quite simple, but if you don't get dictionary, Webster dictionary with collegiate one like I have right here, give me 1 second. A collegiate dictionary, you need one of these, and Black's Law dictionary, you need one of these. Whenever you are reading the law, you have to have both of these dictionaries, and or Google. I guess Google would do it nowadays, but this is what I did when I was upstate. You would have both of these dictionaries on hand, and it'll help you understand exactly what you're reading. So whenever the judges or the justices, they give their opinions, you will be able to understand in full what they were saying. Certain words have different, or should I say, certain words, they use them in different ways. Certain words, they have many different meanings. You have to find out by what you're reading and what context you're using the word in. I'm gonna get to the standard now. How it came to pass was there was a case in Aguilera and Spinelli. They're two separate cases. I just have the Spinelli case. William Spinelli versus United States. I'm not really going to get into what he was locked up for, what he did. And there was Aguilera. That was in Texas. However, they combined these two cases, and they set a probable cause standard when it came to the officers acquiring information and taking the information, putting it within on the face of the affidavit or within the body of the affidavit, and submitting it to the justice or the neutral or detached magistrate. Hope I'm not losing y'all. But it's clear. So in this case that I'm going to read off, I'm not going to read from Aguilera or Spinelli. I'm going to read from a case that I had used in my case, Commonwealth, here in Pennsylvania. David Stokes versus the Commonwealth of Pennsylvania. This decision was made in the Supreme Court of Pennsylvania. And the justices, they said this, and I quote, they said, the law is clear that a warrantless arrest is not lawful unless there is probable cause thereof. Whether there is probable cause to arrest without a warrant depends on whether at the moment a suspect is taken into custody, the facts and circumstances within the officer's knowledge and of which he has reasonable trustworthy information are sufficient to warrant a man of reasonable caution to believe that an offense has been committed and that person to be arrested has committed the offense. Very simple. The facts and circumstances within the officer's knowledge and of which he has reasonable trustworthy information are sufficient to warrant a man of reasonable caution to believe that an offense has been committed and that the person to be arrested has committed the offense. That's what they say. Reasonableness is the test, but that word "sufficient" is the main word. Sufficient, like it has to be sufficient. Trustworthy information. The source of information can be many different things. It can be a video camera. It can be an eyewitness. It can be, I don't know, a tool. It can be OJ's glove. In that case, that's how. In OJ's case, that's how they won. They used the glove was their main piece of evidence that was the DA was using to help support their conviction of Mr. Simpson. However, his team, they showed how the officers never corroborated the information. That's why they said the glove don't fit. You got to quit. The information wasn't sufficient. That was their main piece, or one of the main pieces, in that case. So the glove was the source of information along with whatever else they had, but information can come from many different places. You never know. But clothing, all different types of stuff. But the facts and circumstances within the officer's knowledge and of which he has reasonable, trustworthy information are sufficient to warrant a man of reasonable caution to believe that an offense has been committed and that person to be arrested has committed the offense. So I'm going to look up one word right now. And I want to look up sufficient in the black law. So I'm going to look at the word sufficient. Give me 1 second. QRS. And my cousin always tell me, like, well, don't you write it down before? I really don't. I like to do it raw and how it is. I really don't have to write stuff down and stuff like that. I pretty much know what I'm talking about from the top of my head. So, sufficient. SUFF. This, once y'all get to learn this stuff, it is very, very fun. Very. And you'll feel unstoppable, man, once you get to learn this stuff. Okay. So, Sufficient. Here we go. Sufficiency of evidence. So I think this word actually, see, sufficient. This is what I was saying about the Black Law dictionaries and the dictionary. Sufficient isn't in the Black Law dictionary. They got sufficiency of evidence and other stuff. So then you would have to go and switch dictionaries. And this is what I did the whole time. Like, you wouldn't find that word. Legal words and English word, regular dictionary words are not the same. They're not the same. This stuff is so fun. Okay, here we go. Here we go. I found it faster on this one. SU. Sufficient. These are very small words. Sufficient. Enough to meet the needs of a situation or a proposed end. Then there's many definitions, but enough to meet the needs of a situation or proposing was the first definition. There's another one, qualified, competent, and all that. Sufficient was one of the major words. And only way to get for officer or information to be deemed sufficient is the information. It has to have some type of necessary fact. Facts are necessary to within the circumstances when it comes to meeting the probable cause standard. They have to be sufficient in themselves. So, in Aguilar and Spinelli, the court, they created a 2-pronged test, okay? And in Illinois versus Gates, they say exactly what the test is, or the names of the prongs, okay? The first prong was the basis of knowledge, and the second one was the veracity prong. So it was the basis of knowledge prong, and the veracity prong. And The basis of knowledge, it informs and the athlete informs the magistrate of his basis of knowledge that the informant is credible. The veracity prong, whether he's truthful. So, in this case, in the Stokes case, they tell you exactly how the steps should go. Please follow me. Hope I didn't lose y'all. If I did, just ask me questions and I'll explain them more in detail. But I don't want to hold. I'm already at 10 minutes. He must know the underlying. Number one is the first. He must learn the underlying circumstances from which the informant concluded the suspect participated in the crime. That's the first one. Number one, read it again. He must know the underlying circumstances, which is the officer, the underlying circumstances from which the informant concluded the suspect participated in the crime. In other words, basically, how did he come by this information? You know, that's what that means. Where did he get it from? What is his purpose of giving it? You know. Second, he must have some reasonable basis from concluding that the informant is credible or that his information is reliable. In other words, if they're using an informant in the case, the only one of the main ways that they would be able to prove the reliability of the informant is if they had used him before in a case prior to the one at hand. That's what would make him reliable. And hence credible at the same time. Oh, okay, yeah, he's reliable because in such and such case versus such and such, you know, he testified to give us information, and this information, after our cooperation, came to be, you know, factual along with the circumstances, efficient, and all that good stuff there. That's it. The underlying circumstances. So when they say the underlying circumstances, that's when the law gets deep. You know, basically they want to know what his intentions of is giving the information. That's one of the things they want to know. You know, what is the reason he's giving the information? Why is he giving the information? You know, I mean, the law gets real deep. Now I don't want to take it too far deep with y'all because, you know, it's very, very difficult to explain. But I'm gonna read it off. This is the probable cause. This is the standard that they gotta meet before they get the warrant when it comes to giving the information, particularly from an informant. Now, an old head told me this. He said, it doesn't matter whether it's an informant or a video. Like in my case, it was a video. It doesn't matter whether it's an informant or a video. Information is information. The same standard applies. There is facts necessary. A fact is necessary to establish legal probable cause. That's why they violate the rights so much, because like I said before, it's hard. So he must know the underlying circumstances from which the informant concluded that the suspect participated in the crime is one, and two, he must have some reasonable basis for concluding that the informant is credible or that his information is reliable. Reasonable basis, man. You can't just get Joe Schmo off the street and say, yeah, we got him. Well, how you know he's reliable? Well, he told us that. That doesn't tell me how he's reliable. How you know he's reliable? How do y'all know this person? That's what the court wants to know. How do y'all know this person? Do y'all personally know this person? Has he given y'all information before? You know, and that's the same thing with if it was a video. The video would have to tell them some type of fact. There's a fact necessary. The video has to tell them, well, you know, did the person have a limp in the video? What set them aside? Or what will set this information aside dealing with this person from the rest of society? You know, it gets very, 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 very complicated. However, that is the standard. That's what they have to meet, and that is a lot of work. That is a lot of work. However, it's the two-pronged test. The basis of knowledge test is one, and the veracity test is two. So anytime, you know, anybody got a case, make sure they get their affidavits. And them are the two things that they have to have, that the officers have to do. The basis of knowledge and the veracity. You know, the truth. So veracity means they have to know the truth. Or what is the truth of the information, the source of the information? Where is it coming from? That'll determine whether or not it's kind of it's hard to explain, man. It determine whether or not the how they came about getting it will determine whether or not that gives the judge the facts and gives the judge the facts and the information. So the fact finder, if you ever heard them say fact finder, that's the judge. He would know what to look for. This is when I say you have to learn how to read. Like, he would know what to look for. You have to be trained in reading and stuff. I had to learn. He taught me how to do it. But facts are always necessary in prior to an arrest being made, or when they're giving information. See, in Illinois versus Gates, what they did was they tried to do away with the 2-pronged test and implement the totality of the circumstances. And in other words, they would go ahead and, like I told y'all before, they would make a bunch of different factual scenarios, stuff that really happened, and then they would paint a picture and then put the picture up, and then they make a one big ass fact, and it ain't the case. There's no other information. It's too bland. It gotta be flavorful, man. The information gotta have some oomph to it. Whereas, that's the man. Because you can't afford no mistakes. You don't ever want to violate nobody's rights. And that was the point of the Constitution to begin with. They wanted to get their freedom from England. That story gets deep too. But I thank y'all for listening, man. If y'all have any questions, man, about anything, man, please feel free to ask me. I'm also got a friend of mine who's helping me out, who's an attorney, and if I can't answer, I'm pretty sure he can, But let me know what y'all think. Remember the 2-pronged test, man. That's the basis of knowledge, man. Look these words up that I'm saying. Y'all can understand what I'm saying. And then I would, if y'all ain't getting the cases, man, I'll find a way to get y'all the cases or whatever the case may be. But the basis of knowledge and the veracity test. 2 prongs that they have to meet in order to get probable cause for information, man, to be sufficient to be able to be put in an affidavit and submit it to a magistrate. All right, y'all. Thank you for listening. Catch y'all later. Peace.